let you go over. Thank you, sir.
Thank you, Your Honor.
Yes, sir. All right, the court will call the next case on the docket, which is CITIBANK versus WANLISS. You'll have to excuse me, I do have a cough drop in my mouth, which I ordinarily wouldn't do, but it's either that or I'm going to be coughing in the microphone, so excuse me for that.
Thank you. May it please the court, Ronnie Bittman, Pearson Bittman, on behalf of the appellant.
And did you want 5 minutes of rebuttal time?
Yes, please.
Okay.
So we're here today. The appellant is making the contention in this foreclosure matter that the judge erred by excluding witnesses' testimony
What did the judge exclude?
Well, the judge would not allow the testimony, basically finding that all of the records or evidence that was going to be introduced.
That's what I'm trying to ascertain. What did the judge exclude? What was the substance of the testimony that the judge excluded?
Well, I think it was basically all of the information that's necessary to prevail on foreclosure case.
You can't do that. You can't just come up here and say, in other words, you're arguing that the judge made an error in excluding evidence from the trial. You've got to show us what the evidence is.
Well, I think that the record shows that they made the analysis that she could not testify as a records custodian or otherwise, whether it was introducing the note.
Why was your client, why was trial counsel, I know it wasn't you,
Right.
trying to qualify the witness as a records custodian?
And it may have been error to use that term, whether she was a
qualified witness.
A qualified witness.
What was the objective there? The objective was to put a document into evidence?
Well, at the end of the day, you've got to put in not only a note, a mortgage, a breach letter, the payment history.
And by stipulation. So you were trying to establish that there had been a default, and this lady was looking at some sort of record, and she was trying to be qualified in order to put that record into evidence. What was the record?
Well, I believe I don't believe, other than the mortgage and the note, I don't believe that there was a specific record that was trying to be introduced. I think that they were attempting to introduce the payment history and other information that...
Right, I guess that's my point. In other words, you're complaining that the trial judge erred in excluding this evidence. You have to proffer the evidence in order for us to look at the evidence and determine whether it was prejudicial to exclude the evidence.
Right.
Well, I mean, you know that, right? Where was the proffer? Your trial counsel made zero proffers.
There was no proffer of
They didn't put the record in and say, Judge, okay, I understand you've excluded it, but here's the record, right? The record's not in the record. We can't look at the record. Actually, the question that was objected to was, did a default occur with payment? And that's when the objection was made. So we don't even know what her answer would have been to that question, right? Because there was no proffer of her answer.
There was no proffer of documents or the answer.
So how has your client preserved this issue for appellate review?
Well, I don't, number one, I don't think that, obviously that wasn't in the appellee's brief. I don't know if that waives the argument itself, but to the extent that there had to be a proffer, there was no documents or exhibits that were presented to the trial court.
No, without the proffer, we don't know if the witness would have said, when they would answer the question that there was no default, or that the appellee's current on payments, or we don't have the proffer document showing the payment history, which would show that the person was either in default or current. So we don't have anything before us in that regard?
Our position would be, and what we contend is that the court essentially in a blanket manner precluded the witness from testifying, precluded the witness or the counsel from introducing any of that evidence. There was no proffer after the fact, but we would submit that...
Is there anything in the record which would indicate that if the person, the judge, I understand your ruling, can I have this exhibit marked as an exhibit, or can I at least, quickly proffer what the witness would have said if asked to, and that the trial judge would have said no? Is there anything in the record indicating that the trial judge would have denied the opportunity to make a proffer?
There's not.
Here's the other problem that I have, Mr. Bittman. The question of the witness, now this was a witness who worked for the successor servicer of the loan, right?
Yes,
this is a witness who had no personal knowledge about whether or not there had been payments made by she wasn't the one collecting the checks. She was looking at a record, right?
Yes.
Okay. And you can't publish the contents of a business record by asking the witness, what does the record say? What does the record reveal? That's hearsay. There's no foundation for the witness testifying. And that's really the only question that was asked. The question was, based on your review of the bank record of this loan, did a default occur with the payment? And the objection was, objection, lack of predicate. That's a proper objection, isn't it?
Sure, but there's also...
That's the objection that the judge ultimately sustained. There was no attempt after that to ask the witness another question. There was a long series of back and forth where there was, there was actually some voir dire done, and there was some other things, but at the end of the day, that was the only question that the judge sustained the objection on, and we can't tell that judge that was error, right? I mean, that was correct. That was correct.
Well, let me go back and say this. You asked if this was a successor servicer. This servicer absorbed or acquired the prior, so it's a different situation than just a transfer case.
Yeah, you know what? I'm going to give you as a given that this lady could have gotten the business records in had the proper questions been asked and had the judge ruled correctly. Okay, I'm just going to give you that for the sake of argument. But I'm really troubled by writing an opinion that says to a trial judge that this question was asked and you sustained an objection, and that's error because it didn't. And in fact, the objection was the right objection. Well, in fact, during the discourse that went on, the lawyer finally actually hit the nail on the head, and I don't believe that she can testify from hearsay from these documents. If she has personal knowledge of that she'd like to testify from, that's great, but to the extent that she's referencing to documents, what you have, I believe there's no predicate for her testimony. That was absolutely correct. It was an improper question.
But she can testify, and she doesn't need to
testify to that. She cannot answer that question. Based on your review of the bank record of this loan, did a default occur? If the bank record isn't in evidence, she can't testify.
I see what you're saying, yes.
Right, that's correct. The cart before the horse.
Right. It has to be authenticated once before it's introduced into evidence, and then she can testify to the documents.
More than authenticated, it has to be authenticated, and the predicate needs to be established for the exception to the hearsay rule. And then it's in evidence, and then she can explain the document or whatever at that point in time, but that's not what happened here.
No, you're right. And I think that and I don't know if that was what the question was asked during voir dire.
No, this was the question that was asked during the evidentiary portion. Based on your review, that's what drew the objection.
Right.
And that objection should have been sustained, albeit they got sidetracked and started discussing something that really wasn't on the issue. But the lawyer finally hit on it, and the trial judge got the right answer. And usually, in most circumstances where the judge gets the right answer, even for the wrong reason, we're compelled to affirm. So even if there was a proffer, the problem here is that this trial judge should have sustained this objection to this question, right?
maybe to that particular question.
Yeah.
But during the voir dire and the aftermath were what ultimately led to the dismissal, the witness had the opportunity, and what the lawyer was trying to do was to, I guess, rehabilitate or to otherwise ensure that the predicate and the foundational lay for the business records exception. And I would submit that with the witness's answers, that was actually done. The witness was able to testify about her familiarity with the books and records, that she was familiar with both the prior entity and the current entity's methodology for maintaining the books and records, that she was trained in both of EMC and Chase's record-keeping practices. She had knowledge of who input the system.
That the record, first of all, we don't even know what record she's talking about, but let's assume that that there had been a record identified, and it is the payment record that she's talking about. Did she testify that the record was made at or near the time that the information was transmitted? Did she testify to that?
Again, I think
Anywhere during the voir dire? Anywhere?
we're not talking about a particular record, so I don't think so.
But you see, you guys have argued all about whether the witness was qualified, whether it's a qualified witness or not, and to put a business record into evidence, first you got to have a qualified witness, and second, the qualified witness has got to say all these things that are in the statute, that it was made at or near the time with information transmitted by a person with knowledge. It's really easy to do. You just ask leading questions of the witness, but you want us to reverse on the basis that trial judge sustained an objection to a particular question which was properly sustained on the theory that at some point in time that this witness would have been able to testify as to all the requisites to get a business record in, and that we would have, they would have gotten this record in, and if they gotten this record in, it would have proven the default. And that's just a lot of speculation by this court, and not something that we do. I'm appreciative of the fact that these are all issues that the appellee didn't even talk about in the appellee's brief. And you're kind of flat-footed on it, but you're not as flat-footed. You're obviously very astute when it comes to matters of appellate law, because you're handling these questions quite well today, even though they weren't in the appellee's brief.
Right, I appreciate that.
You know what I'm talking about here. I mean, this preservation, harmful error. The appellate court, by statute, cannot reverse a trial judge for an error that is one that is harmless, and the burden of showing that is on the appellant generally, and you haven't, how do we know whether, maybe there wasn't a default here? Maybe this lady would have said no if she'd have been permitted to answer the question.
Yeah, obviously the issue of whether there was a default or not was not a basis of the briefings. If I recall, the testimony was, and obviously I could be mistaken, but if I recall, there was a testimony that there was a default or a non-payment. But what we can say, obviously there's technical issues with respect to the preservation, was that if you read the transcript, if you read the few questions that were asked before the voir dire, and then I guess the side track of the full questioning of the voir dire, it was solely on the basis of whether that party was a records custodian or an otherwise qualified person. When the judge gave the indication...
Still would have had to say that the record was made at or near the time by information transmitted by a person with knowledge. She still would have had to say that. Could she have said that? Right. How do we know she could have said that?
All we have to do is speculate at this point that once she cleared the hurdle and testified that she was a qualified person, all we can do is say that all of the four prongs of the business records exception would have been met. Not only that, the fact that this was information from a prior servicer, there's a couple additional prongs that had to have been met.
Well, in order to get the record in, she can't just do it in a vacuum. I understand that she had some familiarity and there was something that came out in the voir dire, but she would have actually had to make inquiry and find out how this record was created, because one of the things you have to show is that whoever made these entries had personal knowledge. So, I mean, you know, that's actually hard to do. I mean, you can do it with a leading question, and every witness will be pre-programmed to say yes, but on voir dire, we don't, to actually establish that she knew that the circumstances of the making of the record, there's a lot that had to be developed here that wasn't developed, and you're really asking us to draw a lot of inferences from what happened.
Well, she testified to the familiarity of the policies and procedures about inputting the information as to who and what department inputs the information.
She was familiar with it, right.
Right, but that's all you have to do.
No, you have to say, Judge, here's the record I want to put into evidence.
Right.
Mr. Witness, Ms. Witness, was this record made near the time that the information is transmitted in there?
Right.
Was it made by a person who had personal knowledge at the time that the entries were made?
Or transmitted by a person.
Or transmitted. You got to answer those questions. I don't see where those were even asked.
You do, but I think you don't get there unless, as you said at the beginning, and I'll fully concede, we're not talking about a specific document. We didn't get to that stage yet. I think what they did was try to clear the hurdle of saying that this person is qualified to testify even, before we go to the four prongs of meeting the business records exception. And what they did was they cut her off at the outset, said you're not qualified to discuss anything. You're the wrong witness. And that's what stopped everything in its tracks. So that's what resulted in the dismissal.
I'm not unsympathetic to your dilemma. You want to say some rebuttal time?
Sure.
All right.
Thank you.
Yes, sir.
It's accurate that you didn't raise any of these preservation issues in your brief, correct?
I'm sorry, may it please the court, David Cohen on behalf of the WANLISS. Judge Cohen, that's not entirely accurate, no.
Where in your brief did you raise that?
Yeah, first of all, my brief was an answer brief responding to the arguments made by counsel, but I did put on page 6 of the brief in a footnote.
Page what?
Page 6 of my answer brief in a footnote. I stated that the appellees are not unmindful of the fact that no actual documents at issue were ever offered into evidence. However, the plaintiff's witness was attempting to testify from the various documents. The appellee's counsel raised a timely objection regarding the witness's attempt to testify from the documents without first laying a proper predicate
You
for
put the
admission.
linchpin argument in a footnote, huh?
Well, again, I'm filing an answer brief and I'm responding to what counsel had done, but there were no documents offered into evidence other than the note mortgage, which I stipulated to. If you look at the transcript further on, after the hiatus, if you will, where we went through the voir dire, which I didn't request.
They can foreclose,
I know that, yes. And actually, I had that discussion on the record with the judge as well.
Well, that wasn't the position you took at the time. You suggested to the judge that they couldn't.
I did not. No, in fact, if I recall, the judge said they get a second bite at the apple in a different form, and I said, yeah, we'll deal with that when the time comes, or we'll address that later. I think I have a difference in philosophy from a lot of guys that handle some of the foreclosure defense. I tend to ascribe to the theory of the case law, which I think this court has also followed, that the statute of limitations is going to run with each successive breach and what have you. I know there's a recent case that goes different dealing with the dismissal context. I don't know how that will ultimately hold up, but no, I believe the bank has the right to re-accelerate and re-foreclose. If they tried to foreclose from this particular acceleration, that's a different issue for a different day. But I think there's case law that all the way up to the Supreme Court that deals with that issue. I guess the Supreme Court's not so much on a statute of limitations issue as it is on a adjudication issue. But that issue was raised. What we found is it seems to be two different approaches to trials. I'm a commercial litigator and have been for years and years, and we prepare our witnesses, we bring in our evidence, we line our documents up and figure out how we're going to get these into evidence, and I'm a firm believer that there's a huge difference between what I know to be right and wrong and what I can prove in a court of law. And what we've seen in the foreclosure context is the banks will try to parade in whoever's next on the rotation with whatever documents they have.
Stick to the facts of this case, sir.
No, and I am, Your Honor, and I raised this in the lower court. We had a witness that she didn't even print the documents out. Somebody printed the documents and sent them to this witness, and they brought this witness to court to try to testify from something that wasn't even offered into evidence, and we raised the objection.
Was it a computer screen?
I have no idea. I never saw it.
Well, you were there. Was she looking at anything?
I never saw it. Never saw it. The, no document was identified, no document was offered. Basically, the witness was asked, is there a default? And this was a witness that had testified that she hadn't worked for the prior company during any of the relevant periods, that she came to work for the successor company after it acquired the loan, and clearly she was about to testify from something she had read somewhere, and as Your Honor correctly pointed out, you can't do that. In the cases cited by counsel in the brief, the Israel case, for instance, the Supreme Court case says you can't testify from this document just because it's a business record until it comes into evidence as a business record. And what it seemed like the plaintiff was trying to do, and it's a little different than what we normally see. Normally, you see the document identified and the predicate laid, and then we go through the voir dire. In this case, it seemed as if they were going to try to elicit whatever the testimony was before showing the document, and then come back around on the back door and say, here's the document. And the second she answered that, the second she was asked the question, I stood up, objected, and that led to the dialogue that ensued. But I think Judge Thompson made a correct ruling given what he had. At the end of the discussion, Judge Thompson said to the counsel, what would you like to do now? And counsel's response was, and I believe it's in the transcript, counsel's response was, I'd like a continuance. You know, she didn't offer any documents, she didn't try.
He granted it, and then he capitulated.
At first I thought I blindsided her. And when I explained to him that, no, I didn't blindside her, in fact, I thought I did more than any other defense counsel would do, and certainly more than I've seen any other defense counsel do in these types of cases, he basically recognized that we were prepared, recognized we had done everything that we were supposed to have done, and basically granted the motion to dismiss. And we would contend that Judge Thompson made the correct ruling given the witness he had and the evidence that was in front of him, and we'd ask your honors to affirm. I have no further presentation. If you have any other questions, I'm happy to answer them.
Okay. All right, thank you, counsel.
Thank you.
Hold on a second, I didn't stop the clock. Let me try to up your, well, I'm gonna let you go over by a minute, because you had just a little over 2 minutes left, so.
Okay, thank you. All right, obviously, we have these technical preservation issues that came from left field a little bit.
Well, that footnote raises one of the issues that are core to me, which is whether the objection that was made was properly sustained, and it was.
Right. We would just submit that where it went from there, I think everybody involved realized that we were essentially cut off from being able to do anything, whether or not she was required to
Well, she might not even have had the record. I mean, you know, we don't know that. I mean, you know, she might, if she had just looked at the records on a computer screen and didn't print them out and they weren't there in the courtroom, she would have never got to testify about what they said without getting them in.
Well, I don't think that, there were definitely records that she was reading off of. Obviously, I wasn't there. Mr. Cohen knows whether the records were printed or not, but it doesn't matter even. The whole reason why we filed this appeal is because there was no clarity with respect to whether a witness could testify as to a prior servicer's records, even in this district, at the time we filed this appeal. There's been some clarity throughout the state after the fact, and at the time I think a reply was filed, or the answer was filed. That Hunter case came out of the first DCA, so between then and now, there's been a little bit more clarity. But at the time, practitioners were really at a loss. Setting aside these preservation and technical issues, the question was whether a servicer or a subsequent note holder can testify as to records of a prior servicer, a prior entity. Now, I think it's a lot clearer that they can, so long as you meet these hurdles. But with respect to this particular...
Well, I mean, employees come and go from corporations, and a qualified witness can testify about the records of a corporation as long as they're able to lay the foundation. But, I mean, you know, we don't even have the rest of the foundation here, counsel. I don't think we're going to be able to help you unless I get outvoted. You're going to need to re-foreclose, and I trust that on the second time around, your client will be able to do it a lot better next time.
Right. Okay. Appreciate it.
Okay, thanks a lot.